my lord, my lady. I appear together with my learned friend, Mr. Michael West, for the appellant. My learned friend, Mr. Tom Tarbury, appears on behalf of the respondent, Secretary of State for the Home Department. My lords and my lady, unless there are any preliminary matters that we need to get into, what I propose to do is to develop my submissions in four chapters. Firstly, the legal principles that we say are particularly helpful or significant in this case. Secondly, the tribunal's decisions. Thirdly, our submissions, following the points that are set out in my supplementary skeleton argument. And finally, relief.
Off you go.
Thank you. The first point I want to deal with in respect to the legal principles is the approach of this court on appeal in respect to decisions of the First Tier Tribunal Immigration and Asylum Chamber. Those principles are very well known, and so I don't want to say very much about them. But there are three authorities that we have cited to assist the court in respect of those principles. ULA, HA, and MS Malaysia. ULA is probably the most useful authority in the sense that it sets out at paragraph 26 a comprehensive list of the relevant principles. So ULA is behind tab 4, page 43 of the authorities. Paragraph 26, tab 4, page 43. And paragraph 26 is on page 51, right at the bottom of 51, going over to 52.
Yes. Shall we just run through those?
I would be grateful, thank you, Lord.
Yep. As you say, all fairly familiar stuff, but I see why you want to emphasise it.
I'm grateful. Also of significance are the observations of the Supreme Court in HA. I won't take you to the passage. I'll just identify it for the purposes of your note. It's paragraph 72, page 80 and 81 of the authorities. HA is behind tab 5, beginning on page 59. So paragraph 72, page 80 and following. The final authority in respect of this chapter, this aspect of the first chapter of my submissions, is MS Malaysia. That may be slightly less familiar to at least some members of the bench. MS Malaysia begins at page 131, tab 8. The relevant principles for the purposes of the restraint or deference issue that I'm addressing at this stage in my submissions are set out at paragraphs 33 and 34 on page 141.
This is Lord Justice Floyd.
That's right.
Yeah. Again, shall we just run through those?
That's grateful.
Well, apart from the identity of counsel from whom they had such assistance, what why do we need this case in addition to Ulla?
I'm not sure it adds a huge amount, my lord. Paragraph 30, I often wonder whether to cite this authority for these sorts of points, restraint and deference. Paragraph 34 may be of some value because it emphasises that where one is in the territory of an evaluative assessment.
I see.
And there's no, in reality, there's no...
Yes, I see. No, that's a fair point. That doesn't quite come over in that quite that form. No, you've persuaded me.
Yeah. Thank you.
Yeah, thank you.
The next topic under the legal principles chapter that I want to deal with is obviously central to the issues in this case. It's precariousness.
Yes.
And precariousness is something that all members of this court will be very familiar with. But given the centrality of the concept to the issues in the case, I think I'll need to spend a little bit of time on it. My submission, so there are broadly 2 points I want to make in respect of precariousness. The first is that precariousness reflects the general calibration, or leads to the general calibration of the proportionality scales in an Article 8 immigration case. It's not a factor to be added to the balance sheet or to one side or other of those scales. It's a factor to be taken into account when, at a relatively high level of generality, a court or tribunal looks at the weighting or calibration of both sides of the proportionality balance. To put it another way, from the perspective of the Strasbourg authorities, in a precarious family life case, you are in the territory, or you get into the territory of exceptional circumstances. And the domestic authorities have explained that exceptional circumstances does not translate into a legal test, but is a pointer to the strong public interest in removal, and to the general position that less weight may be attached to family life in a precarious family life case. And the domestic authorities are clear that those two things result in a, if you like, higher threshold for an appellant such as my client to meet in order to win their Article 8 case. The threshold that has been settled on in the immigration rules and in the authorities is a threshold of unjustifiably harsh consequences. And that reflects the need for a very strong or compelling family life case.
Hang on 1 second. All adjectives.
Yes.
Or adverbs. Unjustifiably. Is unjustifiably harsh different from unduly harsh?
I would rather not get into that debate if I can avoid it.
Yes. No, don't worry, nor am I.
But I'm conscious of that point, my lord, which is why the last point I was making is that this articulation of the standard or test that's been settled on in the authorities and in the immigration rules, Gen 3.2 in particular, is a reflection of the need for a very strong or compelling family life case.
So
that's perhaps the key normative expression, my lord. I'm so sorry.
Not at all. I interrupted you. I was getting along fine, except a moment ago. Do I understand you to say that the concept of precariousness means that there's, to introduce maybe another and possibly not helpful thing, that it's a sort of tilted balance, that what you're saying and accepting is that because precarious family life doesn't count as the same as secure family life, that in effect what's happening is that the balance is tilted against somebody who's family life is precarious.
As a matter of generality.
As a matter of generality,
and
therefore they need a compelling case in order to get the balance back up in their favour.
That's right, my lord. As I put it, perhaps not entirely clearly or well, the precariousness principle effectively calibrates the proportionality balance by requiring more weight on one side or less weight on the other. So it's a concept that informs at a high level of generality the standard to be applied when assessing proportionality. That's one way of looking at it. The metaphor that I've settled on is calibrates the proportionality balance.
Well, it was that's where I fell off.
Right. Well, maybe that's not very helpful. So,
but I mean, I've translated it into a tilted scale. Is that what you?
I think that's the same. If I may,
is it the same? Is that what you're trying to?
It's the same metaphor that we both certainly. I would accept that metaphor. Is another way of trying to say the same thing. I would
right. Was that the first of your 2 points on precariousness?
That's the first of the 2 points. Can I just give you the references, at least, to some of the authorities that are relevant to this? We may have to look at Aguiarco in a bit of depth in the Lau case, but I think the starting point is jeunesse in support of the.
Well, just pausing there. Certainly, the rules and some of the domestic case law all tend to stem from jeunesse. The rulemaker was very keen, for obvious political with a small p reasons, to take language out of the judgment of jeunesse and put it into the rules, because that meant that there was no possibility of a Strasbourg challenge. So, speaking for myself, I wouldn't mind just being shown the passages in jeunesse, but perhaps you were going to do that anyway.
No, I'm great.
Or maybe if they're all quoted in Aguiarco, that's fine.
I think the key authority is Aguiarco, but the first authority that I was contemplating taking My Lady, My Lords to is jeunesse.
Okay, well that's fine. Okay, so you said jeunesse, Aguiarco, and Lal.
Yes.
Yeah.
Let's briefly turn up jeunesse, because it is, as my lord suggests, this not quite a fountain, but a useful last word in terms of the articulation of the principles at the Strasbourg level.
Yeah. Now, so you're doing this before we go to your second point. Yeah, which is fine.
I'm dealing with my first point.
Yeah, no, that's absolutely fine. No.
To make good the point that I put forward in respect of that. So jeunesse is at tab 14, beginning at page 233, and the relevant paragraphs or passages are paragraphs 106 to 109, beginning on 255. Right at the bottom of 255, going over leaf, under the heading, helpfully enough, relevant principles.
Can we read the whole of that paragraph to ourselves? Or sorry, the whole of that sideline section to ourselves?
Yes, my lord.
Yes, okay.
I mean, while you're doing that, it's 108 that deals specifically with precariousness.
Yes.
But that needs to be put into the broader context. That's something that this course makes.
Well, let's read it first, and then you can make your observations. Yes, thank you. Can I just make one point, which probably you're going to make it, but just in case I lose it. Here, in this Strasbourg context, there isn't a distinction drawn between, or there isn't a sharp distinction drawn between where the family member's immigration status is precarious in the absolute sense, they actually have no right to be there at all, or precarious in the sense they only have a limited right, which may expire at any time. So precariousness in the Strasbourg concept really overlaps with unlawfulness.
Yes.
As we, although we've split them out in 117b. Is that that's a correct observation? Is it?
With respect, it is, my lord.
Yes.
And that issue, any potential distinction between unlawfulness and a less than settled immigration status, or precarious immigration status, as that expression is used in contradistinction to unlawful immigration status in Section 117b of the 2002 Act, that issue was explored in the Rupia case.
I'd forgotten that, right.
Which is at tab 10.
Shall we go there now since we've raised it, or do you want we to come back to it anyway?
Well, I've accepted my lord's proposition, and I don't think it adds a huge amount to the issues. But if my lord, my lords and my lady wish to look at it, we've included it in the budget.
Well, just
you might be interested.
Well, let's just look at it very briefly.
So it's tab 10, page 157.
Yeah.
And I think probably the discussion that's central to my lord's point begins at paragraph 24 and following, where the court is looking at what...
Sorry.
Paragraph 20.
Whenever you go to an authority, if you can say where it starts, but the next thing I need is the page number.
Of course.
So I can.
So it's page 165.
Thank you.
Paragraph 24 and following.
Shall we just quickly run through that?
Yes, I'm grateful.
24 and 25.
24 and following, my lord. It's a fairly extended discussion of the Strasbourg authorities.
Do we need to read all of it?
No, it's
it's
my fault for taking us to.
I mean, if the court's interested, it can go through it. But I think the key passage, just to really nail down the proposition that I was discussing with my Lord Justice Underhill, is probably paragraph 44 on page 170, my lord. So that was the key. The issue in Rupia was whether it was what precariousness meant for the purposes of 117.
Yes, that's why 44 isn't really quite the point, is it? That means if you any leave, you're still precarious unless it's indefinite leave. That's all he's saying at 44.
Yes.
The point I was making was a slightly different one, and may or may not be in Rupia, but you thought it was that Strasbourg doesn't make the distinction that 117b makes.
Yeah, that is my understanding of the passages from 24 all the way to 44.
I see. Well, look, it's my fault. I distracted you. If we want to follow it up, we can.
Not at all.
No, okay.
But the point, my lord, it is that Strasbourg, you're quite right, my lord, Strasbourg does not draw a distinction between unlawful status and less than settled status for the purposes of the precariousness principle that we've looked at paragraph 108 in Jeunesse page.
And in this case, we don't have to concern ourselves with this because your client's precarious.
Which is why I don't have the answer to my law's question at my fingertips, because it's, with great respect, not something that I think is going to assist.
No, well, typical unhelpful intervention from the bench. But you make the points you were going to make about some 106 to 109.
I'm very grateful. So 108, which recognises the precariousness principle. This is 256, my lord. Does so with the expression, another important consideration. But what is being said at 108, so again this is 256, what is being said at 108 is that where, from the Strasbourg point of view, there is a precarious family life, it will only be in exceptional circumstances that the removal of the non-settled family member will constitute a violation of Article 8. And I'll come very shortly to Agiaco, which explains what that means. Paragraph 54 of Agiaco. I'll come to that. But for the purposes of the Strasbourg authorities, in my submission, what's crucial is that precariousness is not being singled out as a specific factor that you add into the balance sheet, so to speak. It's a category of case in which the Strasbourg court expects that it will only be in exceptional circumstances that the removal of the non-national family member will constitute a violation of Article 8. So, the precarious family life expectation, if I can put it like that, does not preclude the need to assess the particular circumstances in order to assess the strength of family life and the strength of the public interest in a given case. That's apparent from 107. And it's apparent from paragraph 109 more specifically in respect of the need to, if you like, show proper respect for the best interests of children. So I would respectfully suggest that a proper understanding of those passages, 106 to 109, is consistent with the proposition that I put forward about how precariousness calibrates the scales. It's not necessarily a specific factor you add into the balance sheet. Agiaco, tab 11, page 175. Paragraphs 49 and following, page 195. Explores the concept of precariousness and explains it. We've line marked the entirety of the relevant passages, going all the way down to 60 on 196, and in due course, my lords and my lady, you may want to go back and look at these passages. As I've indicated, I'm sure they're very familiar to my lords and my lady. So I'm going to deal with these passages quite quickly. Paragraph 54 is particularly salient in respect of the proposition that I put forward, page 196. So here we see the court explaining what Strasbourg means by exceptional circumstances and the reason that Strasbourg has used the expression exceptional circumstances. And that's further explained in 55.
Do you want us to read it all?
I'd be grateful if you could at least briefly look at 54 and 55.
Certainly.
Thank you.
Just remind me, if you have it at your fingertips, in jeunesse, how long had the family been present in Holland?
I'm afraid I don't know off the top of my head. I can double check. Perhaps I can give you that information.
Mr. West will be looking for it.
Yes.
1997 to 2014, it reached the European Court in 2014.
Grateful.
1997 to 2007, or something like this, was the period of time between arrival and application for a permit. Something of that sort.
I think that's right, my lord, but we'll double check. So back in Agiaco, 54 to 55 explains what Strasbourg means by exceptional circumstances and the reasons why that expression is used. 56 and 57 then supports my point that all of this translates not into a test of exceptional circumstances, but into, if you like, a general weighting of the public interest in favour of removal and a general reduction in the strength of a family life case in the context of precarious family life. And the court refers to this court's decision in MF Nigeria, a deportation case, as indicating that the correct structure or approach in this respect. See paragraph 56 and the quotation from MF Nigeria. Scales are heavily weighted in favour of deportation, and something very compelling, which will normally be, quote, exceptional, is required to outweigh the public interest in removal. And then we see at paragraph 57, the Supreme Court's statement of the normative underpinning, if you like, of the approach in precarious family life cases outside of the deportation context. It's the last sentence of paragraph 57. In general, in cases concerned with precarious family life, a very strong or compelling claim is required to outweigh the public interest in immigration control. And then the court goes on at 58 to 60 to explain that the Secretary of State's then policy, now rules, Gen 3.2, reflects that normative standard by adopting a test of unjustifiably harsh consequences. So that's how we end up with the test of unjustifiably harsh consequences. And that's clear from paragraph 60 in my submission, page 198. My Lords, my Lady, unless there are any questions about Aguiarco, can I turn to deal briefly with the Lau case, which is tab 7, page 109. Tab 7, page 109. And for the purposes of this aspect of my submissions about precariousness, the key passage is paragraph 68, page 127. I invite my Lords and my Ladies to read the whole of that paragraph. But particularly the text just above G, all the way to the end of the paragraph. So that's page 127. And that test, unjustifiably harsh, is now reflected, as I think is pointed out in Lau, in Gen 3.2 of Appendix FM of the Immigration Rules. That is behind tab 2, page 7 of the authorities. So that's page 7 of the authorities. Towards the bottom of the page, Gen 3.22. And the structure of Gen 3.2 is 3.21. If you get home under the rules, we don't need to look at Article 8. But if you don't get home under the rules, you then apply a test of unjustifiably harsh consequences in order to reach a decision that's compatible with Article 8. And in my submission, that.
And this, I mean, although we're very picky about being sure we got the right version of the rules in front of us for the right decision-making date, 3.2 has been like this forever.
Yeah, we're conscious of that. We took this from the version up on the internet last week, but it's not changed. It was inserted to give effect to Aguiarco, as I understand it. And that's the version that was in effect.
Oh, that I did. That's worth noting.
Could you say a little more for speaking, as it were, as the back marker here? What would it have taken to get home under the rules?
In this case,
Yes.
the applicant couldn't meet the specific requirements of the rules because of the nature of the relationships in question. It was a relationship with sister and sister's children. Those relationships are not specifically recognised.
The rules only deals with parents and children.
That's right.
Right.
Parents and partners and children.
There might have been, if there was a genuine parental relationship, it might have been possible. But and I'll come on to this when we look at the FTT's decision. That wasn't what the First Tier Tribunal found, although perhaps there was some, to use my little friend's language, infelicitous expression. So the only way that under the structure in the immigration rules that this appellant could succeed is through essentially the Article 8 evaluation that Gen 3.22 requires to be undertaken.
Right. Well, let's suppose he had qualified under the rules because of the nature of the family relationship.
Yes.
What test would then have been applied to him?
If he met the various requirements in the rules, then he would succeed. And the implications in terms of Article 8 in that situation were explored in a case called ZT Pakistan and PG India, which is at tab 9.
Sorry,
Sorry, TZ Pakistan, not ZT Pakistan.
Just a sec. Let's suppose he was an unmarried father who didn't live with the child, he had no immigration status himself.
Yes.
But could establish family life. What would the test be for him?
Well, it would, if for one reason or another Appendix FM was completely immaterial, then the test would be the test in Aguiarco.
Yes, but I think my lord is asking if it did fall within the rules, in an obviously not going to be the same situation, just otherwise, if it did fall within the rules, say, for example, exactly the same facts, it's the nearest to it, but a parental relationship. Say the husband wasn't around and he had effectively been the de facto father, which I think does fall within the rules, doesn't it?
Yes.
If it does.
That's right.
Well, now, would that simply mean he would be entitled to leave to remain despite having no immigration status, or would there still be some other test he'd have to meet?
The test, so there are, this would take you to the EX1 provisions.
Yes, I'm really, all I want is a phrase as to what...
Right, I think, okay, so in that situation, and it obviously does depend on the particular nuances of the facts, but I appreciate, I'll do my best to answer my lord's hypothetical. In that situation, I think EX1 would apply, and the test there, if there's a genuine parental relationship recognised by EX1, would be whether it would be reasonable for the children to relocate. That reflects 117B6 of the immigration rules.
Of the 2002 Act.
Thank you. Of the 2002 Act, Part 5A, which we have.
Yes, well, I'm sorry, I don't want to dive into this in enormous detail and divert you, but I'm just interested in whether it's going to be said that the test under Gen 2.2 is in some way more beneficial to your client than it would be if he had a closer relationship.
No, it's the other way around. If he was a qualifying parent, he would then be able to rely on Section 117B6, which we have at page 4 behind tab 1, and that test is reflected in EX1 within Appendix FM of the
So you're right. It is simply, I've just been looking at it, it would not be reasonable to expect the child to leave the United Kingdom.
Yes, which is a more generous test than the unduly harsh consequences test.
Right. So it at this stage, at least, your proposition is that you're accepting that he has to meet a much more stringent challenge to assert that his Article 8 rights have been not respected than he would if he had a closer family relationship.
Yes, my lord. Because he's in the territory of precariousness, if I can use that expression, the test is unjustifiably harsh consequences, and that reflects the need to show a very strong or compelling family life case and we've looked at the authority.
Yes, but it's not because of the test. I mean, I realise you get to this through precariousness, but we're comparing precarious with precarious, somebody else who was precarious but had a closer relationship. The reason why he ends up with a worse test on your analysis is because he has a more distant relationship in blood.
Yes. So there's two levels, if you like, of analysis. There's the general principles in respect of Article 8, leaving aside domestic law that deals with a situation that would otherwise be dealt with by Article 8 simpliciter. And on that, and that's effectively the territory that we're in, albeit that Gen 3.2 tells decision makers to apply the unjustifiably harsh test that the cases have acknowledged. And I know from a recent decision that my learned friend brought to my attention and may say something about in his submissions, a case called Butt, that it was submitted in that case on behalf of the Secretary of State. I think at paragraph 67 this submission is recorded, that Gen 3.2 functions as a complete code in respect of Article 8. Whether or not that is the position, I would respectfully suggest doesn't matter very much, because even if it's a complete code, it's just endorsing or bringing in, sweeping in, the unjustifiably harsh test that Agiaco says has to be applied. But then, my lord, under that level of generality, you have the specific provisions made under domestic law that calibrate the balance slightly differently. So, for example, section 117b(6) on page 4 deals with cases where there is a genuine parental relationship with a qualifying child, British citizen or child who's been in the UK for 7 years or more. And Parliament has decided that in that situation the test should be more generous, in order, I would suggest, to reflect the importance of the best interests of children recognised in the Strasbourg cases, but also there is an element of policy choice which needs to be respected when it comes to an Article 8 assessment. But that's the sort of structure of analysis. I hope that's of some value.
Thank you.
Can we turn briefly to the next point that I want to make? So I've developed my submissions in respect of the nature of precariousness, and I hope the court has those. The next point I want to make in respect of precariousness is that in the light of the nature of the principle of precariousness, there are no fixed rules, and there's certainly no little weight principle equivalent to the little weight provisions in section 1.
So sorry, this is your point. You said you have 2 points you want to make on precariousness. This is the second.
This is the second. No fixed rules, and certainly no little weight principle equivalent to section 117b, 4 and 5. So, in other words, in a precarious family life case, although the normative threshold is elevated if you're on my side of the court, so to speak, it's still necessary to undertake a fact-sensitive evaluation of the particular circumstances, having regard to the principles set out, for example, in Jeunesse at paragraph 107, in order to determine the strength of the family life on the one side of the balance, and on the other, the strength of the public interest. So both sides of the balance need to be looked at in the case at hand.
Can I just ask something which has been in the back of my mind for a while? As you say, I think what you're saying, precariousness it just goes into the mix, and you could, in principle, apply it as attaching the weight on one side or diminishing the weight on the other. But what is the underlying thinking behind precariousness? I can understand clearly the point that if you're precarious because you've got no right to be here, i.e. the absolute case of precariousness, that has a very considerable weight in its own right.
Yes.
But precariousness is really only adds something where you have got a right to be here, but no expectation of being able to stay in the long term.
Well, except that, as I hope clear earlier, Strasbourg doesn't draw a distinction between...
Well, I know it doesn't, but I'm nevertheless looking what... It didn't have to write an essay about this. The underlying thinking about why you need a concept of precariousness is something like this, isn't it? That ignore the other parties to the relationship for the moment. You yourself develop a family life. And it's, as it were, it's at your own risk. You know that you're only here on a student visa, or you're only here on a short-term visa. And if you develop a long-term relationship, it may be interrupted.
Yes, that's certainly part of it.
Well, isn't that almost all of it? What else is there in precariousness?
I think I can go back to paragraph 54 of Aguiarco to answer this question, page 196. I know we looked at this earlier. So this is Lord Reid explaining the basis of precariousness at the Strasbourg level.
Yeah.
And it's the text, but at just above F, going to G.
So on which page did you say?
Page 196, 196,
yeah.
Para 54 in Aguiarco. So the first sentence is the expectation. It's likely only to be exceptional circumstances.
So sorry. G. Which side marker did you say? G.
Just above F.
Just above F. G. Yep, I see. Yep.
In the sentence beginning, that reflects. So, and you'll see when you read that in a moment that there are two aspects to it that go to each side of the proportionality balance. So I let my lords and my ladies read the passage. So on the public interest side, just dealing with the order in which Lord Reid sets out the relevant normative underpinning of this precariousness principle. On the public interest side, what justifies saying that there's a stronger public interest in immigration control in a precarious family life case is the weight attached to the contracting state's right to control their borders.
Well, is that the right way round? The right to control your borders is always there. They're rules, and rules ought to be observed, full stop. That always has, in a sense, the same weight. That's the strong public interest in having a consistent regime which you're allowed to enforce.
Yes.
So, against that is the fact I've now got a loving wife here who's English, British, doesn't want to go to wherever it may be. To which it is an answer that doesn't weigh very heavily, because that's a relationship that you and she formed with your eyes open, knowing that I might have to leave next year.
That's the second aspect, if you like, of the.
But that's the only aspect which the concept of precariousness raises.
Well, I mean, Lord Reid does.
He puts it that way around. All right.
And,
okay.
and I mean, one way to understand this, my lord, may be that if you're in the situation, even if you're someone who has not settled status, so you're precarious, but you're not unlawful. I mean, if you're in a state unlawfully, then inevitably you are coming up against the state's right to control its borders, the sovereignty principle, and its power as a matter of international law to remove you or to require you to regularize your state. So that is, in an unlawfulness in context, there's obviously a heightened public interest there. But even in the less than settled status case context, there's a heightened public interest in this way, at least, because you are needing to rely on Article 8 to compel the state by virtue of a positive obligation, and Jeunesse talks about the difference between negative and positive obligation, to give you a status that you would not otherwise be entitled to under the laws and administrative scheme of the state in question. So in that sense, there's still an element of sovereignty in play.
Well, very much so. And in fact, in a sense, it doesn't really matter. Say you start to say marry your partner in year one of a 5-year visa, there's no real problem at that stage. The problem arises at year 5 when it's about to expire and you have no right under the rules for it to be renewed. And at that point you are unlawful, or at any rate they're contemplating the position that you would be unlawful unless special discretion. So it all comes to the same thing, doesn't it?
I think that's probably why, albeit that when you are assessing the particular strength of public interest and the particular weight of family life in a given case, the Strasbourg authorities are clear. You don't have any bright line rules, and this is the point I'm developing. So there is a scope for sort of nuanced weighting, but I think that's why the Strasbourg court doesn't draw a hard line distinction between unlawfulness and precariousness in the broader sense.
Well, the reason just for my own general clarity of thinking, why I was just asking for your help on this fairly obvious point about what the underlying thinking is, crucial to it, I think, and this appears in the wording we see in anti-argument journalists, is the point about awareness. You did it with your eyes open. And at some point, but I suspect you're about to come to that, how does that affect children?
Can I deal with that right now? I'll take it slightly out of order, but I think it may be helpful to do it. So the second part of the justification that Lord Reid refers to obviously looks at the strength as a matter of generality of family life rather than the strength of the public interest. As my Lord is aware, what Strasbourg says is, well, and I'm paraphrasing perhaps inaccurately, but I'm going to do it anyway. You don't have a legitimate expectation of being able to stay in the state if you know that you're in a precarious immigration status situation. Still less if you're unlawfully in the state, but Strasbourg doesn't draw a distinction. But that thinking turns on an awareness of the parties to the relevant relationship of the status, the precarious immigration status. And we submit that in the context of a family life with children, young children at least, that aspect of the precariousness principle is inevitably reduced in its force. In other words, young children cannot be expected to know that the person that they have a relevant family life relationship with has a precarious immigration status. And coupled to that, although it's a conceptually distinct point, is the emphasis in all the authorities, Jeunesse at paragraph 109, for example, that it's vital to take the best interests of children into account as a primary consideration, not the primary or dispositive consideration, but a primary consideration. And this is the submission we make at paragraph 11 of the supplementary skeleton argument.
In fact, yes, exactly.
Just to go back, sorry to interrupt, Mr. Biggs, but just to go back to the point that Lord Reid is making towards the end of paragraph 54, which you just showed us. I think you very fairly you were making a point against yourself, which is that there's a second potential underlying reason for this principle, which is not to do with legitimate expectation or whatever, but is a separate point, which is that if the convention can be sort of used as a tin opener for getting around your breach of the rules, that's not an altogether good thing.
Is the fait accompli point?
Yeah.
Is that it? Yes. And I certainly acknowledge.
I think, speaking for myself at the moment, you're right. There do seem to be two strands to the precariousness point, not just the knowledge point.
And the way I see it, for better or worse, is that those two strands go to different sides of the proportionality balance.
Yes, I see it. Well, I rather scuffed over that. When I was
Sure, it's my fault. I didn't.
No. You made the point very clearly, as I say, very fairly, because it's in a way against your case.
I'm grateful. Now I should. Sorry, my lord.
You may not be intending to deal with this, but or deal with it at some other stage. What do the authorities say about the principle that states have the right to control their borders in cases where a state hasn't shown much inclination to do so.
Yes. I'll deal with that point now. That's another of the factors that I say have to be taken into account when looking at the specific weight of family life and the specific weight of proportionality under the heading that there are no fixed rules and certainly no little weight principle. So I've already made the point in answer to my Lord Justice Underhill's questions about best interests and how all of that works. Perhaps just before I move away from that, just to close that loop, if I can say so, best interests and how that all works in Article 8 is explained in a recent decision of the Supreme Court called CAO. That's at tab 2, page 9.
That's the Northern Ireland case.
That's right. And it's only there because it's the most recent sort of vessel for the relevant principles. Zumbus is more directly salient, but the relevant part of Zumbus is quoted in CAO. So the passages I'd ask my lords and my lady to note in respect of how best interest works as a matter of Article 8 law are paragraphs 49 to 51, page 26 and following.
If they really only summarise Zumbas, speaking for myself, I we're pretty familiar with those.
No, I don't ask the court to go to it because this should be very, very familiar. But that's the citation. That's why CAO is there. And so that's the second aspect of my response to my Lord Justice Underhill's question about how children cases fit into the precariousness framework. You've got the normative implications of the justification for precariousness, this lack of legitimate expectation. That has diminished force in a child.
Yes, you said diminished force. Logically, I would have thought insofar as it depends on legitimate expectation, it has no force.
Yeah. But okay, the reason I perhaps I'm being too fair to my learned friend, but the reason I say it's not quite no force is because of the Button Norway case, which we deal with at footnote 4. Button Norway is tab 15, page 256.
Yes, I didn't read that last night, so I'd just be grateful if you tell what it says.
So the relevant paragraphs in Button Norway, I think paragraphs 27 to 29, page 281, I hope that's the right. Sorry, no, those are I've written that, the paragraphs down incorrectly. It's paragraphs 78 and 79, 281.
Can we just quickly read those?
Yeah. Well, it's
right,
paragraph 79 in particular that I'd asked you to look at for this purpose. But the context is 78. So that's at the bottom of 282.
I see, yes.
Over to 2.
78 is rather long, yeah.
Yeah.
Okay, let's just look at 79 then.
Well, it's it's setting out sort of established principles anyway.
Yes.
So what's being said at 79 is that if the authorised, if the authority in the state in question has properly, sustainably formed the view that for interests, because of the need to respect the state's ability to control immigration, it's appropriate to treat the position of the children as essentially coextensive with the position of the adult, then precariousness comes into play in perhaps a full-throttled way. You effectively remove the fact that the children don't know about the precariousness of the person they have relationships with, immigration status. So in that way, I say that I acknowledge that the Strasbourg authorities do recognise that precariousness might have something to say even in children cases, but only in that specific situation. And so that's perhaps only a limited inroad into my general point of paragraph 11. That's, my lord, why I don't go so far as to say
that's very clear, thank you.
Can you remind us of what the immigration status is of the sister and her husband and children?
They're British. British citizens, all of them.
Well, they are now. When they came in 2016, presumably they weren't. They came on some proper route and have acquired citizenship.
I think that's right. We'll clarify just in case I'm.
But they've all the sister and the family, I've always understood, have been lawfully in the country throughout.
That's certainly right.
Maybe that the sister's husband is British.
That's possible. Yes.
We'll clarify. I'll correct.
Right, but I mean, just when we're thinking about the, as it were, the sister and her family being the anchor on which your case depends. It might be otherwise if they had no status themselves.
Of course. Well, then you'd be in a very different situation.
Well, then you'd be pulling yourself up by your own bootstraps.
Potentially, yes. Yes. Perhaps the anchor metaphor is out.
Yes, I don't know. Maybe you have instructions now.
Forgive me. I'm sorry, we don't have a definitive answer, but we will get it.
I think we can be fair. Well, we'll hear from Mr. Tarbury. It would be pretty surprising if they were here illegally that hadn't unlawfully that hadn't been come out at some point.
Right,
but it would still be useful to know the formal position.
Yeah, and we'll make sure you have the correct information. So that's the significance of children when it comes to the necessary fact-specific evaluation in respect of precarious family life cases, including the best interests principle. My Lord, to go back to my Lord's question, was asking about the significance of delay in immigration, enforcing immigration control. That is dealt with in one of the passages that we skimmed over, or I skimmed over, in Jeunesse as well. It's paragraph 52. Sorry, not Jeunesse, Agiaco. Mm-hmm. Paragraph 52 on page 196.
Can we look at the EB?
Yes, we can.
As well.
Yes. So I'll just let my lords and my lady look at 52, and then we'll go to EB cross.
Yes. We needn't go back to Jeunesse, but Lord Reed's last line is illustrated by the judgment of the European Court in Jeunesse. I'm right. Basically, the decisive factor in Jeunesse, why they were allowed to stay, was that they'd been there a very long time already and nobody had done anything about it.
Yes.
That's.
I need to
there may be some nuances,
right.
but.
I need to. I'm sorry, Lord John.
Yes.
I need to think carefully before I would endorse the idea of decisive, but certainly a very significant factor. It may be that's the right.
I'm pretty. Yes. Okay. Well,
it's just I need to go back. Certainly very significant. Yes. So EB is at tab 17, page 303, and the salient passages on page 332. Are paragraphs 13 to 16, 332 going over to 334. And in particular, 14 to 16, you have Lord Bingham explaining how delay is significant.
So we just quickly, it's a familiar passage, but shall we just quickly read through it again?
Of course.
It's basically three ways, yeah.
Yeah, exactly. And the second of those three, at least, expressly is framed expressly in terms of precariousness. An immigrant without leave to enter or remain is in a very precarious situation, etc.
This is pre-Jeunesse, but we're sort of plugging into authorities which Jeunesse itself reflects. Yeah.
For example, Button always is quite an old case.
And Bultif, yeah.
Of course. And you, my lords and my lady, will see that those three ways operate on different parts of the proportionality balance. So the first and second reason, certainly second reason, seems to be relevant to the strength of family life. But the third reason, paragraph 16, is relevant to the weight of the public interest. And that reflects Lord Reed's way of looking at it, paragraph 52. Now, I accept when a decision maker or tribunal or court comes to undertake the difficult Article 8 evaluation, they need to avoid the danger of double counting, but still, conceptually, they're relevant to both parts of the balance. So, before I move away from this topic, no fixed rules, certainly no little weight principle, I think we'll need to look briefly at the Laing case. But the specific principles I've looked at, how precariousness is dealt with in respect of children cases, if I can put it like that, and the relevance of delay in enforcing immigration control. These are examples of how there needs to be a fact-sensitive assessment of the proportionality balance in a precarious family life case. Laing is at tab 7, page 109. And the section of the judgment that in due course I'd ask the court to carefully consider is paragraphs 50 to 68, page 122 to 127. I'm afraid for some reason the line marking didn't come through. We should have line marked all of that, so I apologise. So it's 50 to 68, paragraph 50 to 68, page 127 to 127.
Yes.
And the essential proposition, there are two propositions that emerge from these passages. The first is the point that I've been making, that there needs to be a assessment of the weight of family life and the weight of public interest considerations in a given case in the precarious family life context. There are no fixed rules. And secondly, the little weight principles or provisions in section 117b, 4 and 5 do not apply outside of the scheme of section 117b. Mr. Malik, on behalf of the Secretary of State in Laos, had made the contrary submission at paragraph 52, and that submission was rejected. So the key passages to make good those two propositions are paragraphs 64 and 66 to 68.
So, which paras?
64,
Yep.
page 126. And it's the text at line marking H, the sentence beginning, the point is.
Yep.
And then similar reasoning at 66 to 67. Paragraph 68 in respect of the,
Yep.
the test. So, my lords, my lady, those are my submissions on precariousness. Can I turn then to deal with the tribunal decisions?
Yep.
The First Tier Tribunal's decision is at page 102 and following in the core bundle. This is the pagination in the bottom right-hand corner. If anyone's using a PDF, it may be page 104 of the PDF. And I'm sure the court has gone through this document carefully, so I will go through it fairly quickly, but of course if the court requires any specific assistance, then I'll do my best to provide it. You have a sort of general background to and following, setting out the applicant's immigration history, the appellant's immigration history, page 103. An identification of the issues under appeal at 5 to 8. summary of the proceedings, recognising that all evidence was heard at 11 and following. Then a correct acknowledgement of the relevant immigration rules at paragraph 16. An accurate statement of the principles in TZ Pakistan at 17. And then at 18 and following, the judge sets out in my submission accurately statements about Article 8. Paragraph 18 talks about not a complete code. That might be debatable now in the light of Butt, although I'm not sure that in the recent Butt decision, my learned friend may refer you to, the submission that Gen 3.2 constitutes a complete code was accepted, but nothing turns on that. That's my submission. Because the same assessment is required one way or the other. Paragraph 20, the learned judge identifies Part 5A of the immigration...
An oddity, I don't think this matters, sure it doesn't, but 18 refers to MF Nigeria, but that's in the Upper Tribunal.
That is...
Should the reference not be to the Court of Appeal? Doesn't. Maybe not.
I can't remember whether there was...
Maybe there's something. No, okay, don't worry.
The statement, the citation's perhaps not apt, but the statement...
But the statement is correct, yeah.
Paragraph 20 identifies Part 5A of the 2002 Act and acknowledges that these are mandatory considerations. And then...
Well, yes, right.
And
are we not... At some point, you're going to have to deal with why she was talking about 117B. I mean, this is 117B, isn't it?
The judge sets out 117B, but
although she doesn't actually give it that label, we can see that's what it is.
That's right. She sort of cut off 117B, but clearly it's 117B, the text
that
appears. But in fairness, what the judge is saying, albeit in perhaps a compressed way at 20, is there's a scheme under Part 5A that requires the tribunal to have regard to various factors when assessing Article 8 in an immigration case. And then the judge sets out Section 117B as identifying factors that have to be considered in all cases. And of course, this is not a deport case, so 117C would not be relevant. So the judge was correct to set out Section 117B.
I suppose so, in a formal sense, but in fact, it had no application to the case in front of her.
That's right. And when I'll come to the judge's application.
Yes, okay.
There's a degree of formality.
The first bit of 117 is relevant, isn't it? So subsections 1, 2,
yes.
And
that's right, my lady. My learned friend.
My lady's right.
Aggressively at me that
I'm wrong.
Right. So yeah, I was too quick, my lord. Forgive me. Yeah. So and as I say, 117B, as the judge rightly points out, is applicable in all cases and provides a sort of general structure. Now, we don't have the authorities on this, but the way 117B works is that, to some degree, is a sort of benevolent shortcut. So if you get home under those provisions, particularly 117B6,
it's a bit of a mishmash. 117B. Yes. Some of it is, as you say, benevolent shortcuts, but as you yourself just pointed out, my lady pointed out, one is not a benevolent shortcut. No. That's a fundamental principle.
And 4 and 5 are and also factors that have to be taken into account, or principles that have to be factored in.
Yeah. I think each subsection needs to be looked at differently, because they all work in different ways.
Right. Now, as my lady points out, 1 is general. It's always going to be there. And so is 2. But 3 to 5 will, and 6, although it's doing something different, will depend on the particular circumstances as to how far they're applicable.
Well, if we're being we mustn't. 2 and 3 are of the same character. They are particular factors.
I'm sorry. Yeah.
Which will count against you if you can't do them. Or count against you if you can't speak English. Or count against you if you're not financially independent. 4 and 5 are little weight type provisions, which also count against you, but in a different way. And then 6 counts for you.
6 is, yes.
6 is the benevolent
Benevolent
shortcut.
shortcut.
Yeah.
That's the right structure.
Yeah.
I respectfully accept that. Thank you. Then the judge sets out at 21 the need to take into account the best interests of the children, page 107 of the blue pagination. Burden and standard.
The last sentence is technically wrong, but the spirit of it is right. Is that right?
I think in the light of CAO it is wrong, but nothing turns on that because the same principles had to be applied via Article 8. So section 55, no. Article 8, Zumbas, yes. You put it like that. Standard and burden of proof, 22. Then findings, 23 and following. The judge then, on 108, refers to the immigration rules. And looks at the specific case that there would be very significant obstacles, rejects that case in the following passages. And the conclusion is, I think, 36.
Now, 1 second, sorry.
So the judge looks at 276 ADE and the argument that there were very significant obstacles.
Yeah, so his private, that Bango's his private life case.
Yeah.
Yeah.
Quite. And just on that, my lord, because I moved past it quite quickly, paragraph 7 on page 103, in my submission, makes it very clear that the appellant's case was based on family life, not private life, or at least was primarily based on family life.
Well, to be fair, no. Private life is at 6.
Yes.
And family life is at 7.
Yes, but certainly there was an independent family life argument.
Certainly.
Sorry, that's the point. And as my lord, you rightly point out, that case effectively failed because it depended on the rules and the rules weren't met. We then, at paragraph 36 and following, page 110, get to the rules in respect of family life that are relevant, and Gen 3.2 in particular, applying the unjustifiably harsh consequences test we've discussed. And in paragraphs 40 to 46, this is an important part of the decision, the judge makes findings about the strength of the appellant's family life with the children of his sister and with his sister. And finds that there would be unjustifiably harsh consequences for the children in the event of removal. And in respect
just one second. Yes, thank you. Yeah.
And in respect of sister as well, see paragraph 40, end of 45. Paragraphs 43 and 44 we should perhaps just alight on for a moment or two. In my submission, what paragraphs 43 and 44 are doing is recognising that the applicant appellant, has a particularly strong emotional bond with a degree of dependency in respect to the children. The language used in paragraph 43 is a special relationship with those children. That's the second sentence.
Can we separate out the judge's findings from what people were saying to her? When I see it's a sort of roundabout way, but I mean, previously, quotation from the sister's statement.
Yes.
Now a sort of a backhanded assessment of the relationship. I think you have a finding at 44, which is a direct finding.
Yes.
And what
Yes, I'm sorry, yes, and so I don't want to interrupt my lord's train of thought, but 41, there's another, just doing the exercise, the second half 41 is also a clear finding by the tribunal.
Yes.
May not be
yes.
I'm grateful.
quite such strong language as one would like, but anyway, it was clear to the tribunal. Yep.
And then, and then we get to 44, and the first sentence of 44, it was attacked by the grounds of appeal before the Upper Tribunal. I do find that he is effective. I think that should be effectively taking on the role as the third parent in the household, and then you have, in my submission, what the judge means by that in the following part of the paragraph: person of huge significance in their lives, etc. So the point there, my lords and my lady, is that the judge is not finding that there is a genuine parental relationship for the purposes of, for example, section 117b(6), and the authorities that the respondent relied on before the Upper Tribunal. What we see in the first part of paragraph 44, that first sentence, is the judge using an analogy or metaphor to try to communicate the depth of the bond and connection between the appellant and the children.
Slight oddity in this that there's actually nothing about the role of the father.
No.
We know that the mother has a back problem, so some of the things you expect the mother to do, she can't do. We guess that he takes them to school and so on because the father is at work, but that's only a guess.
Yeah.
But nobody's asked us to look at the underlying facts, so...
No. The issue, the grounds of appeal before the Upper Tribunal were very narrow. There's no respondent's notice.
Yeah,
so,
no, but that's fine.
So the tribunal then comes to the conclusion that Gen 3.2 is made out, paragraph 45, and also makes a finding about best interests consistently with Gen 3.3 at 46. And on that basis, the judge says, well, the rules were satisfied. Then the judge comes to consider Article 8 and does that from paragraph 47 and following. The first thing the judge points out at 47 is that she's brought forward her analysis in respect of the rules. And I think that's entirely the right analysis, bearing in mind my lady's judgment in Butt, as to the structure that needs to be followed in cases like this. There's a finding that there's family life, 49, and then at 50 and following, we see an assessment of proportionality. There's then, for some reason, some perhaps unnecessarily extended discussion of whether there could be family life. I'm not sure how relevant that is, given that we're dealing with children, but be that as it may, that's what you have there.
Which paragraph are you?
Particularly, well, paragraph 54.
Oh, I see, right, yeah.
I mean, this is the Kugathus type situation, but there are children involved in this case. I mean, it would be relevant in respect of sister.
I suppose so. Kugathus is about siblings, isn't it? But it's also about family relationships other than. It's more the general principles in Kugathus are not just about siblings; they're about other than parent relationships. So perhaps
conventionally, it's understood. Certainly, I might be wrong. I've always understood the Kugathus principles as concerning adult relatives, not necessarily children, because Strasbourg has
yes, I see.
Different principles. There doesn't seem to ever be an issue if you've got some kind of genuine relationship with a child, and then that's enough to show family life, or at least different principles apply to those considered in the Kugathus.
So the reference is to more than normal emotional ties between adult family members or something.
So yes, but I was just wondering whether it's also relevant to say there's more than normal family ties, there's more than normal uncle, nephew, niece.
Mm. Well, we've seen those findings.
Well, exactly. That's why. Anyway, it doesn't matter.
I mean, that's perhaps an academic discussion that we don't need to get into.
No, in this case, it's all about the children.
Agreed.
I mean, you don't get anywhere with the sister on her own.
Yes, absolutely, and that's what the judge is saying. The judge's reasoning is based on the best interests of the children and the implications for the children in the event the appellant was required to leave the UK.
Yes, it's not about him. It's not about his sister. It's about the children.
Yes, it's not about private life. It's about family life, and in particular, it's about family life with the children.
Just to be unnecessarily picky, it is certainly primarily about the children. You're entitled then to put into the balance
relationship with sister,
the relationship with the sister, and him. I mean,
yes. Well, and this is
he shouldn't suffer by being.
Yes.
But to that's never going to get you home.
Yes, and I've accepted that
Okay.
As my lord pointed out to me, there was a private life case, but there was also a family life case, and it's the family life case that succeeded, particularly by reference to the children. But of course, there was a relationship with sister, and that was found by the judge as well. And the two are connected because the children's mother is the sister. So, paragraph 59 and following, under the heading section 117b, the judge then goes through public interest considerations.
Is it right that the appellant speaks very good English? Because earlier on in the determination, she records that he started off giving evidence in English and then had to rely on an interpreter.
Yes,
speaking for myself, I found that a bit peculiar.
Perhaps. Well, we have what the judge says about it.
But I mean, it wasn't a ground. It wasn't a ground.
No, I mean, the presenting officer did actually make a point about that in passing, I think, at the hearing in the Upper Tribunal, but acknowledged that it wasn't a ground of appeal, as my lady just says. So,
I'm grateful. I accept.
I think it's unlikely that it is odd, but it's unlikely the judge would have said it if she didn't mean it.
Well, I think we have to assume the judge meant what she clearly
Well, she heard him
said.
give evidence in English.
Yes.
For a bit.
I mean, he's perfectly entitled to give evidence through an interpreter if he wishes.
My lord anticipates the point I was just going to make, that the mere fact that someone uses an interpreter doesn't mean that actually their English isn't adequate. I mean, if we were in the heat of cross-examination, I think we would all want to use our first language if we could. At least the instinct to do that, the choice to do that, is not necessarily incompatible with having adequate English for the purposes of Section 117b.
I think there's some reference in the original decision letter to his position being strengthened by his ability to speak English on a return.
Maybe, my lord. We have the decision letter at the end of the bundle.
Yes,
124. So, from 59 and following, the judge goes through various public interest considerations that are relevant to the 117 schema.
Hang on. It's yes and no. 117B, 61, he has no criminal convictions, isn't a 117B factor.
No.
And really, the rest of 61 isn't exactly a 117B. 117B doesn't really talk about the immigration history. By definition, you've got a bad immigration history.
That's fair enough. I think what the judge is effectively saying is these are factors that are relevant to the public interest and perhaps the strength of the family life, which I have to take into account, and some of them are mandated for me to consider under 117B. So the judge has used the sort of subheading 117B as a placeholder for that broader assessment of the public interest. And in that section of the decision, the judge looks at those aspects of the public interest that 117B says are significant, or which would be relevant under the broader requirements in 117B, if I can put it like that. At paragraph 63.
Sorry, can I just got one other question? I think there's a decision somewhere, there's probably several, I think I'm responsible for one of them. It's about 60, saying that you can't really put into the credit balance the fact you speak English. The schema of 117B is that if you don't, it'll count against you.
Yes, I think that's probably, it's a neutral factor.
It's a neutral factor, but she's not wrong to mention it. No.
Well, she had to take it into account.
Yes, no, she's okay. Thank you.
Otherwise, that perhaps would have been a ground of appeal. And what the judge does is to look at how the particular circumstances might diminish the public interest in the particular case. At paragraph 63, there's a particular point in that regard about contribution to society. Now, I acknowledge this might be a fairly generous point, reflecting Boris Johnson's observations at the time, but there's no challenge to it. And then at 64, we see the EB Kosovo point, the paragraph 52 of Agiarco point, diminishing the public interest in support of immigration control is diminished because since 2011, the respondent has failed to give effect to immigration control. I don't want to be too contentious, but that's broadly what the judge is saying.
Yes, she's plugging it in effectively to Bingham limb 3.
Yes.
Looking at that again, I think it's 2 and 3. That the third limb of the Kosovo case seems to be about 2 people who started going through the system at the same time and came out with different results, and that was said to be haphazard, as it were. But I thought the second limb,
Isn't this
at the end, if I can just find it.
Yes, page 333. That would be enough.
333.
333.
it's basically the whole immigration system is a shambles, and he doesn't say shambles, he says dysfunctional.
Well, I was looking just above that, but because it didn't seem to me that your reliance on paragraph 16 fitted very easily with your own client's situation, which was not to do with the fact that it was, my word, haphazard, but more at the bottom of the second one, letter F on that page, months and years without a decision to remove. Months pass without, months become years, years succeed years.
Yes,
The sense of impermanent fades, and the expectation will grow that if the authorities had intended to remove the applicant, they would have taken steps to do so.
yes. So I think that's focusing on the strength of the family life side of the balance. I put it in terms of reasonable expectation.
Well, I'm not so. I mean, we can get terribly conceptual about all of this and our balances and calibrations and scales and so forth. And it's helpful to separate things out, but in the end, you have to look at the reality of the situation. And it seemed to me, from this passage, that it was really at 333F, at the end of paragraph 15, that we were in the sort of territory that you might be referring to, which was basically inaction. That it's one thing to say it's very important to control your borders, but if you don't actually do it, then you may not be entitled to quite such so much weight in respect of that factor. Once months become years, and years become more years.
Yes, well, I think that is the point, but I think strictly there are probably two aspects to that point. There's the point that's being made at 15F, which is you're going to get used to the fact that you're allowed to be in the UK as a de facto reality. So you're not going to feel a sense of impermanence, and that's going to strengthen your family life. And then paragraph 60 makes the point that I think, my lord, you were actually putting to me, which is that the public interest tends to be reduced in a case where, for whatever reason, the state has just let someone remain.
Well, I think you have this point also in the last sentence of paragraph 15,
Very well.
which is, depends on no legal doctrine, but an understanding of how, in some cases, minds may work, and it may affect the proportionality of removal.
Yeah.
Isn't that putting it also in that way?
I think so. Yes, that goes back, as I was putting it earlier, I used the idea of legitimate expectation that you'd be allowed to stay in the UK as one of the two underlying principles in respect to precariousness. One was sovereignty and the need to ensure proper immigration controls on the public interest side. And in terms of the strength of the family life side, there was this sort of psychological aspect that if you're allowed to stay in the UK, you might have, even when you're not meant to be here, you might have a reasonable expectation that situation will be allowed to continue, and that will have psychological implications.
But I don't see that there's reasonable. I don't see this reasonable expectation at all. You're just getting away with it. Not a reasonable expectation.
No,
but if the system is not set up in a way so that it polices its rights, then it becomes capricious to arrive at any old moment and say, now we're going to enforce them.
Yes.
Isn't that the point that we can take from this? And it'll carry different amount of weight and depending on the circumstances. But I mean, in the present case, which is a fairly common one, your client was there to be found, just keeping his head down and getting on with it.
Yes.
He should have left.
Of course.
When he was required to leave. But he didn't, and nobody enforced it, and that was what the FTT had to deal with. That's what your decision maker had to deal with.
and the judge properly factored that in a way that was plainly, we say, with great respect, open to her at paragraph 64, page 116.
Again, I don't think it was a ground of appeal that she was wrong to factor it in. We might argue about exactly the basis, whether it's Bingham 2 or Bingham 3, and quite what goes into Bingham 2, but if there isn't a challenge, there isn't a challenge.
No, and one way, I mean, I made a point earlier about double counting, and I think I would accept my law's observation that there's a danger of perhaps getting overly conceptual here. One's trying to apply a practical standard, or a standard in a practical way. And that's what the judge did.
And some of the factors affect the balance, and depending on how you look at them, they might be said to increase the weight to be given to the family life in question, but they might also be said to reduce the public interest in removal in a way it doesn't necessarily matter
Yes.
which way you classify it, as long as it's taken into account overall.
Yes. As long as the weighting, one way or the other, is open to the judge or decision maker.
And there isn't any double counting, which is you were.
That's why I sort of encapsulate with the idea of weighting being open to the decision maker, because as I say, you've got to be conscious of double counting, but that's not an issue that arises. And so then the judge decides at 66 and 67 to allow the appeal because the fair balance, the proportionality assessment falls in favour of the appellant.
What's the judgment? What's the judgment of Lord Justice Sedley has been referred to? In which case is that from?
We think that might be VW Uganda, but we haven't double checked. Now,
VW Uganda.
yes, which is
not about this.
No, it's an old case, and the submission that I would make on that is that the judge isn't there trying to bring in some new and contentious principle. What the judge is explaining is her reasoning in respect of fair balance, bearing in mind everything else that's been set out in the judgment.
So it may not be an apt citation, but it supports the finding. It goes to the finding of the final sentence far more than mere hardship.
Yes.
Which,
whether it was wise for the judge to refer to that particular case and that passage, the passage is not incompatible with the correct principles. And reading the judgment as a whole, we say the judge applied the correct approach and reached sustainable conclusions and made proper findings in respect of.
But also, you've banked the finding that there were, if your argument is correct, that the appellant's removal would have unjustifiably harsh consequences.
Yes.
yeah.
And unjustifiably harsh is the right test, and so the judge.
Yes. So it doesn't matter what she said here
No.
if the other finding is sustainable.
Yeah.
My submission.
Sorry, it looks to me, I searched VW Uganda and I was offered cars in East Africa.
We can get the citation.
I then added Sedley and came up with the judgment in VW Uganda. I think that what is quoted here may be a quote from E.B. Kosovo, and that what Lord Justice Sedley was doing was quoting from E.B. Kosovo. So I think we may arrive back at the same.
So it's even perhaps more apt in one way but less apt in another.
Yes, but what is said in VW Uganda is recognition should be given. Paragraph 44. If removal is to be held disproportionate, quote, what must be shown, and then that quote.
The difficulty of the problem, I think, is what Lord Justice Sedley saying. It's not.
Yes.
Well,
The question in any one case, says Lord Justice Sedley in his own words, will be whether the hardship consequent on removal will go far enough beyond this baseline to make removal a disproportionate use of lawful immigration controls.
Yes, and of course that's not. Well, I say of course. In my submission, that's not incompatible with the unjustifiably harsh formulation. No. That sounds pretty close to it, frankly.
So that's the FTT.
Yes, Upper Tribunal's decision.
It certainly won't take so long to read.
No. Page 76 is the core. PDF 78 for those of you. And as my lord indicates, I probably don't need to spend too much time on it. The court can read it. Very, very brief. paragraph 1 summarises the grounds. Paragraph 2, 77 of the repagination, sets out the judge's reasoning on error of law. That's the extent of the judge's reasoning on error of law. And it's the third to sixth lines down where we see the crucial reasoning. Judge does not correctly self-direct in respect of Article 8, and in particular, at no point in the decision is there reference to the little weight to be attached to a private and family life garnered in the context of unlawful and precarious status.
So you say that's a clear misdirection because it's a reference to 117B, I can't remember if there's 4 or 5.
Yes, that's our primary submission because that seems to be the best way to interpret the judgment.
Well, it doesn't say anything about 117B there, but it does in the next
Lovely,
sentence.
so
So
I was
it
just
calls,
going to come on to that.
yes,
But the language, the little weight,
yes,
Little
no,
weight
quite.
is we say.
where
on
else does
analysis,
it come from?
Exactly, it has to be a reference to 117B 4 and 5, and then the judge refers to section 117, strangely, because section 117 has nothing to do with anything. It's not even in part 5A, but I think we know that the judge is trying to get into part 5A.
No, there's a bit of looseness.
And in response to Mr. West's submission, he actually made another point, but we don't need to get into that as well. So the judge is there rejecting Mr. West's submission to sort of explain her conclusion.
Yes, this is all part of the first point.
Yeah, that's my submission.
Yeah, no,
So this is all
I think that's obvious.
117B at 4 and 5.
Yeah.
I won't take you through it in the interest of time, but it's important potentially to note that actually this judgment came through after an extempore judgment, which we have in the core bundle at page 79.
Well, by chance I read that first, stupidly. So
I'm not sure there's a huge amount of difference, although the point about perversity is dealt with differently. And it may be that the right analysis is that the point about perversity, the so-called perverse finding at, I think, 44, that actually didn't feature in the judge's error of law decision at all because of the way she dealt with it as an extempore.
Well, I think you're stuck with that now.
Well, we may have
Sorry, we've got ahead of ourselves.
No, we haven't.
Parrot 2 gives 2 reasons.
Yes.
The first, which is what we were just looking at,
Yeah.
and that goes down to the word adequate dealing. Then the rest deals with quotes perversity, but the judge says, no, I'm not finding perversity, I'm finding irrationality. And the actual point, forget the labels, is the reference to the relationship as being a parental relationship. So that's actually the point.
Yes. That's what the judge says, and I accept that it's probably not open to us now to try to say that because of the way the judge dealt with this, sort of after she gave her extempore judgment, that can't form part of her decision. We're not
Your argument is she didn't characterise it as a parental relationship.
The First Tier Tribunal.
Yeah.
That's our submission. Upper Tribunal judge was just wrong to say there was a finding of parental
So basically, she found 2 errors of law, and you say that they're both wrong.
Yeah.
The errors. They weren't errors. There might have been other things that were wrong with the FTT decision.
Right.
But they weren't those.
That's right.
Yeah.
And then at paragraph 3, the judge sets about the remaking.
Yep.
And again, the reasoning is pretty brief. We can go through it together now if that will assist.
But if we just pause, I mean, I know you're keeping us moving forward, but in that's an important point after paragraph 2, namely because if paragraph 2 is not right, then the Upper Tribunal had no basis for intervention at all.
Of course, yes.
So we
absolutely.
ignore the remaking.
And then we ignore the remand. And I've certainly been in such cases where I have been in cases where this may not be one of them. The remaking was impeccable, but we just said, tough, you didn't get to the point where you're entitled to remake.
Yes, and that's our primary submission. Our primary case is it wasn't open to the Upper Tribunal to set aside the FTT's decision.
Yeah.
Certainly, the Upper Tribunal.
So if you're right about that, if you were right about that, in a sense, you just sit down. I mean, what is following is in case you have to meet the further case.
Yes, my lord.
And that you're not right about.
If somehow this reasoning is correct and the FTT did err for the reasons given by the judge, then there is a separate argument that the judge herself erred in respect of the remaking.
Yes.
Yes.
But
Well,
we-
okay, well, just run us
That's,
through
that's
that.
your, that's your second string, very
yeah.
much.
Yes, very much our secondary submission.
Okay, but you're just showing us.
I'm just
well,
showing you the
show us.
reasoning to set up the points which I'll come to shortly and go through quite quickly in the light of what's gone before, but as to why we say the appeal should be allowed. So paragraph 3 sets out the judge's reasoning in respect to remaking. We say, just to flag the point, there are 2 very clear errors here, at least. We actually highlight 4 in the written argument, but I'm going to focus on 2 because I don't think I need to do more with respect to the Upper Tribunal. The judge says, in around the middle of the passage, paragraph 3, that the best interests of the children would not be a significant or dispositive factor. Now, dispositive, fine. Significant is not compatible with Zumbus and the correct principles in respect of how to approach best interests.
Is that
not right.
very fair reading? Because clearly, if she's not, but if you read the sentence as a whole, isn't she saying because the relationship, because the harm to the children isn't going to be all that great, square brackets, because they're only nephews and nieces, it's not so detrimentally affected that in the facts of this case it's a significant factor.
Yes,
I
agree.
Well, it may be that
My
reading
Lord
it in
agrees.
context, the
She's
point's
not-
quite
she's not
as strong
setting
as
a
I thought
test.
it was.
I mean, I think your point is she's setting the wrong test, but reading that sentence doesn't seem to me at least that she's setting a test at all. She's expressing an evaluative conclusion.
Well, what she's saying is that the best interests of the children are not a significant factor in
on the
context
facts of
any
this
reported
case,
evidence.
she's saying they're not, which is just perhaps a slightly clumsy way of saying
Because she's saying
they don't weigh very much because it wasn't that strong a relationship.
It may be that looking at it in context, it's not as strong as a point as I had first thought. But it is fair to say that the judge is at serious risk in saying, well, this isn't a significant factor because the authorities are clear that best interests of the children have to be.
I think we can
any
agree
time.
it was an unwise way to put it, but we have to be fair to her, as
All right.
we have to be fair to the FTT judge.
I certainly
Yeah.
wouldn't invite you to do anything else. The second error, which we say is tolerably clear, is the error about the significance of delay. That is apparent from the last part of paragraph 3. What the judge says is that there's no evidence of suffering prejudice, and therefore the factor isn't significant. Well, that, in my respectful submission, is just not compatible with E.B. Cossington and Agiarco at 52.
And also, there's no reference to the impact on the children. I mean, maybe that's not relevant.
No, well, I think
Because,
that goes.
because you know, that he's not the only person involved in this assessment.
Well, that takes me back to the point that perhaps the court wasn't attracted to, which is that the judge hasn't properly dealt with best interests of the children.
Yes, it was a nitpicking intervention on my part.
Well, no,
But it might be a different facet of the same point.
I mean, what the judge had to do in respect of best interest was follow the factors that are set out at 51 of CAO by reference to Zumbas properly. And in my submission, the reasoning doesn't do that.
So there's no Zumbas, basically. Because looking at the practicality of this, the Upper Tribunal judge was remaking the decision, but the First Tier Tribunal did hear from the parties, at least from the family members, rather. And although the Upper Tribunal judge in remaking the decision was not obliged to hear oral evidence, one might expect this decision to include something quite substantial about the children's situation and the relationship following a Zumbas. So would it be, I'm just trying to work out, are you really saying that given that she did not hear any evidence, it was all the more incumbent upon her to do a Zumbas exercise?
Yes, the judge had to properly factor in best interests of the children, applying the well-settled principles in Zumbas. And the reason he wasn't sure that was done.
How would this work? Normally, I'm sure we don't get a representative sample. We tend to see cases where the rehearing is on a separate occasion. As my lord says, sometimes, quite often, further evidence is called. Sometimes it isn't, but at least you tend to the bundle is before it, presumably some sort of note of what
Sometimes
the evidence.
there are preserved findings.
Yeah, preserved findings. This has all been done very much in a rush.
I fear that may well be right.
We must assume that. What did she have? She had the Did she have? She had a bundle, presumably, with witness statements in it.
Yes,
Did she have the so-called record of the proceedings, which we never see? But
I'm not sure about that. She probably should have done, but I can't say whether it was.
Does Mr. West? Perhaps we can just ask Mr. West. Mr. West, did she? Do you know whether Judge Davidge had?
Mr. DeBory.
Sorry.
That's Mr. West. Oh, sorry, Mr. West. Yes. Sorry. My fault. I'm being stupid.
Well, no, there was no record of proceedings before the Upper Tribunal when she remade the decision.
Right, but I am right in thinking what's called the record of the proceedings, I have seen it once or twice in odd circumstances, is effectively the judge's manuscript note of the evidence. Isn't that what the record of proceedings is?
Yes.
Well, Mr. Bates knows it. He's been around longer than you.
Yes.
And I assume that came up with the file, so to speak, to the Upper Tribunal, but it wasn't referred to. You wouldn't have it.
No.
You'd have your own. You would have your own notes, but
I don't. From memory, I don't want to misconstrue what was happening. But from my understanding at the time, there wasn't any reference made to any record of proceedings.
no, don't worry. That you've told. It's only very much a background point. I'm just trying to understand how this pretty. We got the transcript. I mean, this pretty brief hearing. What the judge was looking at and what she had. But anyway, you've told me enough. Thank you.
It was really a remaking on the basis of what the Upper Tribunal had in terms of the First Tier Tribunal evidence and determination.
Okay, thank you.
Did the parties agree that the judge should go on to remake if she found an error of law?
I think that's right.
That was their
While my learned friend was addressing the court, I was just looking through the transcript.
Yeah, I was trying to
it's
find.
clear. It's
Page
clear.
91.
I was trying to find the passage between.
No,
I
it
would
was
also, in fairness to the judge, she was, if we look at page 85, she was allocated half an hour.
Yes.
Yes. I make no criticism of anyone, but
No,
it does seem as though this was.
I was being a bit careful because we don't know how it happened, but the end result is a surprising end result. I don't mean the result of a case, the result of a hearing of this character, deciding essentially factual and evaluative issues of this kind.
Yes. I think, though, I am entitled to point out on behalf of my client that the judge could have reserved her decision if she needed more time.
Yes, she could.
to work through
No.
the document.
I'm guessing it's a possibility. Of course, if the appeal had been overturned on perversity, then in a sense there's no need. There has to be a formal rehearing, but the basis on which it's been overturned necessarily dictates the result of the rehearing, and then you would certainly do it on the same occasion.
Yes. Yeah.
But that wasn't
If
actually
there's
the way
only
it
one
went.
right outcome, then it sort of follows from
Exactly.
Yeah. So
Right. Well, sorry, I've distracted you.
No, not at all.
But you're really nearly there.
I am
aren't you?
nearly there. So, but just to close this loop, if I can respectfully put it like that, page 91 of the core bundle, at the bottom of the page, you'll see that the judge in the Upper Tribunal appears to have proceeded on the basis of the findings made by the First Tier Tribunal.
What's the reference?
Page 91 of the blue pagination, PDF 93, page 10 of the transcript of the hearing, just at the bottom between G and H. This is where there is the discussion about how to approach the remaking. The judge says the findings are there, and I read that as indicating that the judge
Yes.
was essentially of the view that the fact finding had been done by the First Tier Tribunal, so it was just down to her to undertake a reassessment of proportionality.
Going to be
Well,
what facts? If the findings were that there is if the facts include the evaluation of the depth of the relationship,
It
the
may
result
be
ought to have really gone the other way.
Is an evaluative assessment of fact for these purposes?
Yeah.
No, quite. I mean, it's a tricky area, but still.
Yeah. It may be that the error that I say arose at para 3 in respect of a failure to properly assess best interests was almost inevitable because of the approach the judge took. But that I just sort of flagged that possibility. So can I turn then to the submissions, and I can be brief because they're
You've very brief. You've already made them.
I've made them.
But still, I don't want to stop rushing.
No, I'm grateful. I don't want to miss anything. I've set the arguments out in our supplementary skeleton argument. There are 4 reasons we say why the ground of appeal, the single ground of appeal, which I appreciate has 2 aspects, should be accepted. The first submission is that the First Tier Tribunal's analysis was open to it, and you've got our submissions in writing. I've made all the points, I think, already as to why that's the case. The short point is that the 2 short points are that Section 117B 4 and 5 were not apposite in respect to the judge's conclusion, because that was based on family life, and those provisions didn't bite in respect to the particular family life in this case, and nor was the little weight idea applicable outside of the scheme of Section 117B for the reasons I've gone through. And so standing back, what the First Tier Tribunal judge did was to properly assess Article 8 in the context of a precarious family life. All the judge did wrong, if there's anything to be said, if the judge did anything wrong in the First Tier Tribunal, it is not setting out Agiarco and making clear that this is a precarious family life case. But we know from the authorities in respect of restraint or deference that the judge is not required to do that. What matters is the judge's substantive analysis. And the reality, my lords, my lady, is that this sort of case is very common in the First Tier Tribunal. The judge may well have not appreciated that it was necessary to state the obvious from her point of view, which is that this is a precarious family life case. That's our first point. The second point is one I've already made. It's that there is no little weight principle in respect of precariousness outside of Section 117B. We make that as a second argument because we had understood the Secretary of State to suggest otherwise, but that argument was made in Lal and rejected in Lal. I don't propose to take any more time on it. Thirdly, this is paragraph 13 and following of my supplementary skeleton argument. With respect to the Upper Tribunal judge, the reasons the Upper Tribunal judge gave at paragraph 2 of her decision are not sustainable. And finally, paragraph 19 of the supplementary skeleton argument, if you need to look at the judge's remaking decision, we say that you don't need to do that because our primary case that the Upper Tribunal was wrong to set aside the FTT's decision because there was no error of law. If you do need to look at the remaking aspect of the Upper Tribunal's decision, we've identified 4 reasons why that decision is unsustainable at paragraph 19. I focused on 2 of them in my oral submissions. And I don't want to say any more about that because I've covered the points, unless there are any questions. Finally, in terms of relief, very straightforwardly, if you're with us on reasons 1 to 3 in my skeleton argument, then the Upper Tribunal's error of law decision should be set aside and the First Tier Tribunal's decision should be restored. If you're against me on reasons 1 and 2 at least, and you're of the view that the Upper Tribunal was right to find an error of law and set aside the FTT's decision, we say that the Upper Tribunal's remaking decision is unsustainable. And in the event you need to look at that and you're with me on that point, the correct disposal of my respectful submission would be remit to the Upper Tribunal for a fresh hearing there. My lords, my lady, those are my submissions, unless you have any questions.
I think you would say in front of a different judge. I believe my lord, my lady tells me that Upper Tribunal Judge Davidge is retired anyway, so maybe
it may not be a practical consideration.
Yes, okay. But in principle, it probably should be in front of a different judge.
Yes, I confess I'm not sure what the apposite principles would be there, but that would be a prudent course. I would expect.
Anyway, okay, thanks. Thank you. Thank you very much indeed, Mr. Biggs. Yes, Mr. Tarbury.
Thank you, Lord. So I will start with and focus on the error of law decision. And as you've seen, the error of law decision is basically just paragraph 2 of the Upper Tribunal's judgment. It's very brief. The remaking decision is also brief. Paragraph 3 is about twice the size or slightly less. And the error of law decision comprised two particular errors, as you've heard from a learned friend. Primarily, the misdirection or failure to properly apply a direction point. And then, as I pointed out in my supplementary skeleton, referring to the transcript, the judge essentially had to be persuaded to deal with the further ground of the Secretary of State at all, namely rationality. But her focus was on the misdirection point. And the misdirection, I'm going to call it that, the judge's phrase was, does not correctly self-direct, I'll call it misdirection, was in relation to this principle that you've been hearing so much about, namely precariousness. And I'll use that as the broad term because, as has been discussed already, when we're looking at that principle out with 117b4 and 5, i.e. in the jurisprudence, it's a composite term, if you like, spanning both the precariousness of being non-settled and having no leave to remain at all.
The way you put it implies that you accept that the judge was wrong, as I think it's clearly did, to label the misdirection as a failure to refer to 117b 4 and 5. She was wrong about that.
Well, my Lord, on that specific point, and we'll see this perhaps a bit more clearly from the Upper Tribunal decision of Regendran that this court has affirmed, that this broader principle of precariousness is effectively seen or reached via the lens of 117 broadly. So whilst within it you have 4 and 5, these specific quantities, I think there's reference in fact to the lens as a term, is how they are reached. So a reference to 117b isn't a misdirection or a failure to look at a statute that doesn't apply. It's rather that it's broader, and we see that from 117a even. But I'm happy to look at that specific point now, if you like, my Lord. Or
up to you, but as we're on it, and if you're comfortable with it,
yes.
so whatever suits.
I mentioned Regendran, so if I could take you to that into the authorities bundle, it begins on page 203 of the authorities. Paragraph 39. The tribunal said, follows when answering the public interest question posed by section 117A 2 to 3.
Let's just have a look. So which paragraph do you say?
39.
I haven't seen this before. The sideline passage starts somewhat earlier, at 36. Is it helpful to read in?
That's actually a more specific point, my Lord, that I think leads up to a conclusion which is not contested in these proceedings.
Right, okay, straight to 39.
Yes.
Thank you.
If you, just given the time I have available in particular.
Well, I am just going to look at 38.
Yes.
So, starts rather oddly, but quite dense. Okay, I need to give up. I might look at it over lunch, but 39 is what you want us to look at. Follows that when answering the public interest question, a court or tribunal should not disregard precarious family set out in. Well, that's fine. That's.
Yes. I'll carry on when you finished reading.
Mm-hmm. still haven't read it completely fully, but surely all that's been said is that precarious family life considerations, which, as we've seen, effectively are there in jeunesse
Yes.
and in agiato, will be relevant, even though they are not relevant under Part 5A.
Yes.
Yeah.
Yes. So you can look at it two ways.
So the judge did get it wrong to plug this point into Part 5A. You may be saying, yes, but not as a matter of substance. That's fine. But all I was putting to you at the start was the judge thought this was a point under what she called Section 117, but she obviously meant Section 117B.
I'm sure she did, Judge. That's my point.
Oh, I see.
So if it helps to
Yes,
go
sir.
back to maybe this is the nature of responding. You've already seen sort of the.
No, fair
I'm trying
enough.
to start with principles, but you've already seen the judgment. So let's go look at the judgment. So paragraph 2 of the Upper Tribunal's judgment, the reference is to 117 broadly. There's no 117B.
Yeah, I mean, it's sloppy anyway, because it's a...
Because
But
117.
you're right. Clearly, well, I accept that, but 117A isn't relevant either, is it? The whole of Part 5A isn't relevant, is it? I mean, on the question of precariousness.
I would say that it is, my lord, solely because it effectively has become the frame, if you like, through which all Article 8 is reached. And you noted early on, my lord, about how the wording from jeunesse has essentially been adopted into this, and so on. It's become the main anchor, if you like, whereby rather than there being some sort of Article 8 assessment outside the rules, now it is all here in primary legislation.
But it isn't all here. That's the whole point.
But my lord,
It's surely this.
Yeah.
Have I not got this right? Part 5A says the concept behind Part 5A is Article 8 will require you to do a balancing out between certain circumstances in a particular case and the public interest. Here are some particular provisions which you are obliged by statute to take account of in doing that exercise, but it's not exhaustive.
Yes.
That's clear from 117A, subsection 2. Considering the public interest question, the Court of Tribunal must, in particular, have regard, blah, blah, blah.
Yes, exactly.
So,
Thank you, my lady.
I don't want to get too hung up on this. At the moment, I'm not quite seeing how you're defending the judge's reference to Section 117, well, let's call it Part 5A,
Yes.
reference to Part 5A, except as to say it's a sloppy shorthand for precariousness generally, in which case fine, but it's still sloppy.
Well, my lord, if it was somehow, and this is the point that my friend tries to make, that I think certainly in the supplementary skeleton that she meant 117B4. Never mind that she doesn't say anything about that. But she doesn't say that. She simply says 117 because it is, as my lady just points out, all right, it has particular qualities, and 117A2 refers to them. There is the broader question of Article 8 and Section 117.
Yes, but Part 5A does not
leads
say
you to it.
you must have regard to Article 8 and all the jurisprudence about Article 8.
No, but it does posit the issue of the public interest question.
What it does do is, as it were, provide a starting point
Yes.
for the consideration
Yes.
of Article 8 by making certain considerations mandatory, relevant considerations.
Yes, and it even defines it at 117A3.
Yeah. In other words, it's saying to decision makers in the tribunal, you've got to look at this question. In other
Yes.
words, is it justified or not?
So it echoes, if you like, of my lady's judgment in Butt about the excellent submissions made by the Secretary of State, who was saying that this is a complete code now because there's
We haven't seen Butt yet, but
there's no Article 8.2 freewheeling analysis anymore. It's all in here, and you might get to jeunesse and Strasbourg and so on via 117 pretty promptly, rather than getting into the weeds of 117B. But you still start with 117, and that's all the Upper Tribunal's saying, really.
Okay. So, but it's legitimate. Effectively, your point is it's legitimate to treat Part 5A bracket, which is what Section 117 means,
Yes, but the additional point
as as a label for the whole Article 8 exercise, for the whole Article 8 balancing exercise.
Yes.
And that's all the judge was doing.
Yes, and my learned friend indeed said when he got to 117B, never mind that its component parts weren't considered and it wasn't strictly applicable to this family life that wasn't a qualifying partnership, that it was a placeholder, i.e. the approach in the specialist tribunals is to treat 117B as this lens.
Exactly. You're saying if it is a mistake, it's the same mistake the FTT judge made. Yeah, but I take your point. Okay.
But the broader and
I don't like all these metaphors are unsatisfactory. Lens is particularly unsatisfactory.
No, okay.
Anyway, yeah, okay.
And so.
Okay. So that's your answer to my point that it wasn't illegitimate of her to refer to 117 in that overall label sense.
Yes.
Okay.
And it would be particularly immaterial, my lord, or if it were an error, which it's not, as I've just hopefully shown, because we can agree, and indeed my learned friend now makes very clear he agrees, that this precariousness principle was applicable and was engaged. Therefore, if en route to saying this is a very important consideration and it must be applied, as the Upper Tribunal very much did, and the First Tier very much did not, you happen to refer to the wrong statutory provision, it really would be quite immaterial because you've got to the key question.
But the question is surely, I mean, all of this is to do with labelling.
Yes.
And what they meant by the labels
Yes.
they used. But the fundamental point, as I understood the Upper Tribunal judge to make that justified one of the 2 points, intervention,
Yes.
was that the First Tier had not sufficiently dealt with the public interest
Yes, exactly.
in a precariousness case.
Exactly.
So your substantive issue, which you're no doubt going on to, is going to be whether in fact that was a fair criticism.
Absolutely. Mm-hmm. Absolutely. So with those sort of opening
that's
points
helpful.
dealt with, you can do it in two stages really. The first is obviously to look at the principle, and then second is to look at the First Tier judgment. Neither should take too long, but given my learned friend's already taken you to them. But I do want to take it in that approach, if that is all right. The first, as to the principle.
Are you looking at the clock because this had a half-day estimate? I'm not sure it did have a half-day.
I thought it did, but if
I
it's
think
not,
it does. No. You can certainly go over lunch if you need to.
Okay.
Depends how economical you are.
Okay.
But
See how it gets on.
don't rush yourself unduly.
I might just give you references, given that you may have come across them.
Up to you, do. Yeah.
I wouldn't take anything for granted if I were you.
No, I'm not taking anything.
In relation to me,
absolutely. I certainly happily go back to them because it helps me to see them afresh. Certainly. So
don't rush yourself. Lunch is not an immovable barrier.
Okay. So let's start with the Upper Tribunal's judgment then, so we remember squarely what was said and what the very narrow error that was found in this case, which was not a rationality, despite going on to deal with Mr. West's additional rationality argument.
Well, that's a distinct argument.
That's a distinct argument, and
Yeah,
it was
okay.
sufficient for the Upper Tribunal to find just one error.
Yes,
that,
right.
until they were she was pressured effectively to say more.
Yep. Okay. Let's
so
deal
in paragraph
with this one.
2, page 77 of the core bundle, judge does not correctly self-direct in respect to Article 8, and in particular at no point in the decision is there reference to the little weight to be attached to private family life garnered in the context as here of unlawful and precarious status. Mr. West argued that the reference at paragraph 65 to the real significance of the public interest in maintaining a firm but fair immigration policy and protecting the economic wealth is a sufficient self-direction in the context of the reasoning of the judge as a whole. But in the context of section 117.202, that is not an adequate dealing. And that was upholding a ground of appeal which is at page 98, the Secretary of State's grounds, paragraph 2, where the Secretary of State argued that under the heading making a material misdirection of law on any material matter, it is respectfully submitted that the First Tier has incorrectly undertaken a proportionality balance when allowing the appellant's appeal on Article 8 grounds.
Sorry, where are we? I'm looking at 98. Where
98,
are you?
paragraph 2.
Paragraph 2, 98. I've only got paragraph 1. 1, making perverse or... This is page 98 of the bundle. Reasons for appealing. First heading, making perverse or irrational findings on matters material to the outcome. Where there isn't a paragraph 2.
There is over the page.
Yes, apologies, I gave you the wrong page
On
number. It's
page
99.
2, making the material mystery.
Oh, I see. Sorry, you gave the
Begins
wrong.
on 98. You're quite right, I'm sorry.
No, it doesn't matter at all. But
So and then at B, we get closer into it. Submitted, the First Tier has failed to consider the appellant's private family life on the basis that it was formed whilst the appellant remained in the UK unlawfully with no valid leave to remain. Subsequently, it's
That is, I mean, just as a statement of fact, that doesn't seem to be correct, is it? I mean, I quite understand that the Secretary of State might profoundly disagree with the decision that was taken by the FTT, but to say that the judge in the FTT failed to consider the matter, I don't see how that can survive a reading of the quite extensive decision.
My Lord, we can go to the First Tier judgment now.
Yes, but I mean, you are saying that, I mean, that the First Tier judge failed to consider this question.
Yes, when we look at the judgment, we will see not only is there no reference to precariousness, there is no weighing the weight of the family life relationship on which the appeal succeeded in light of, calibrated by, to use my own friend's phrase, the fact that it was accrued exclusively whilst the appellant had no leave to remain.
Very well.
Right.
Rob, do you want to go there now, or had you?
Well, if I could just complete the principles.
No, do of course, absolutely. Yeah.
They the principles really are just as to the importance of the consideration. So if, in particular, we start from Jeunesse at 108. Page 256. Another important consideration is, and then the principle is stated. So its importance is being declared by the Grand Chamber. That's the first point. And the second is after Rajendran, the Supreme Court gave its judgment in Agyarko. If we could go to that next at 195.
So that's all you want from Jeunesse?
That's the sole point. It's about the importance of it. Because the thing, if I could just make this point now, you had long discussion about what the principle entails and how it should be applied. But the narrow issue in this appeal is the failure to apply it in the first place. The point I tried to make in the supplementary skeleton is that whilst you might need to adjust it according to the Lowell point about there being degrees of precariousness, for instance, or soften it in light of the delayed enforcement EB Kosovo point, if you haven't had regard to it in the first place, that's the error. And we see from my learned friend's own submissions, but also from the Grand Chamber's own judgment at 108, and now at Agyarko, paragraph 49, page 195, where Lord Reed uses the same phrase, but it's worth reading the whole of paragraph 49.
Sorry, page?
195.
Yep.
The next principal case to go to is but, which I'm afraid is not in the bundle, but copies should be on your desk, and you may have it downloaded. very recent decision of this court at paragraph 68. So in this case, 117b(4) was applicable, so the statutory route to the precariousness principle was engaged. But my submission is that, given the height of this principle, given that everyone from the Grand Chamber to Lord Reed says it's an important consideration...
So sorry, I was just writing a note. Where are we in Butt?
68, my lord, for this point.
Yes.
So as I say...
68, paragraph 68.
Yes. So the principle there is that it's necessary for the tribunal to expressly apply the statutory requirement in 117b(4) when it assesses proportionality. That, as I say, is where 117b(4) is engaged. It's not here. But that doesn't change anything, I say. The height of this principle is such that it's not sufficient to somehow be aware of it, which is the word Melfrin uses in his supplementary skeleton. It requires express application. More than that, if we stay within but, paragraph 80, please, in the discussion in the conclusions. Although the tribunal did recite the relevant legal provisions, it did not approach them in a structured way or make reasoned decisions about them. So never mind that there's no citation in the first tier's judgment of this principle, the failure to direct in accordance with it, there isn't what comes from that, or should come from that, and what was necessary applying but. So that is probably sufficient on the principle, namely, it exists, it's unavoidable, it must be expressly cited, it's very important.
So what has got to be said?
Beg your pardon?
What has got to be said? Give us a sample direction.
Something like either reference to the quotes from the authorities, or simply I note that this family life was accrued at a time when there was the...
Right, so the magic self-direction is to use the word precariousness or a thesaurus equivalent.
As long as the wording means the same principle, then yes, absolutely, yes.
Right, but I mean that's all an FTT judge has to do then, to demonstrate awareness of the importance of the precariousness idea.
Yes, if there's something along... So, my lord, you said some interesting points earlier on about how effectively we have a sort of seesaw that's sort of preset at a particular candour.
I didn't say that. I'm afraid, with all respect, I have great difficulty in deciding whether one is calibrating seesaws.
Tilting. I think my lord did use the word
tilting balances, or just putting more or less weight into one or other side of the scale.
They are the same thing, ultimately. They are the same thing.
Yes.
But the point is, we can all agree it makes a difference.
Yes.
That if your relationship with your nieces and nephews was accrued when you had no right to be...
But you're accepting, for the purpose of this submission, that you could have a grand citation from authority on precariousness, or you could simply say, I hold in mind that this person's status was precarious.
Yes, absolutely, yes.
So that's all that's needed. Right. And the consequences that flow therefrom.
Yes, you'd have to sort of see that it made a difference, and it wasn't just sort of mention at one...
That it's relevant, that it was precarious.
Absolutely, yeah. Note it, apply it, etc. Reason from it. But to turn to the first tier's judgment then, paragraph 20 is the citation, the quote from 117b. And as discussed, given its sort of narrower, discrete versions of precariousness, unlawful residence weren't applicable, doesn't stand as consideration of the relevant principle we're talking about.
But the fact that a specialist judge quotes a statutory provision which says that little weight should be given to private life that is established when the person's immigration status is precarious doesn't constitute a self-direction?
No, because Judge, it didn't apply, because this only applies to private life or relationship formed with a qualifying partner or private life. So it wasn't engaged. So even if ignoring the point in but about recitation being insufficient, it didn't apply. So the most it can be is the points that the bench has suggested that it might have been in here as relevant under subparagraphs 2 and 3.
So that citation about Article 8 can be ignored.
Yes, effectively. Certainly no answer to my point. The next paragraph to have a look at is paragraph 24. Here there are some sort of brief facts found in a list. And none of them is about family life having been accrued when he didn't have, when he was here unlawfully. In paragraph 40 is the note that the appellant's sister came to the UK in 2016, which was after he'd already ceased to be, his appeal rights had been
Sorry,
exhausted.
just
Yes,
the second point. There was no reference to him being here unlawfully.
in that little list of facts, there's nothing.
I understand that, but in paragraph 3, she refers to the fact that his appeal rights were exhausted in September 2011.
Yes.
Under what right did the judge consider he was here?
Yes, I absolutely accept that. That's noted in paragraph 3. Going to paragraph 37, the judge turns to Gen.3.2 and the unjustifiably harsh consequences provision in the rules now. And within it, it's a focus on the impact on him and on the family life relationship. There's no consideration within it of the public interest considerations, if you like. And that is significant for a number of reasons. Firstly, because unjustifiably harsh encompasses the balancing act. That's why it's not just harsh consequences, but unjustifiably so. So this isn't being applied as a complete answer to the Article 8 question here. It's just a recording of the extent of impact. And it's also the case, as confirmed again in Butt, that one only then proceeds to go outside of the immigration rules and these provisions where there is some compelling circumstances not contemplated by these rules. And there's no finding here that I must do that. Rather, there's this sort of now quite old-fashioned reference to MF, Nigeria, and this sort of two-stage approach. But anyway, the Gen 3.2 section finishes at 46, and then the judge goes on to consider this essentially outside the rules assessment. Under the heading Human Rights, the findings above are brought forward. Finding of family life. And then at 50, the judge says, I'll now turn to look at proportionality, which has its own heading. 51, I find the appellant meets the rules. Well, that's an error, though it wasn't point taken, because as we've just seen, the meet the rules finding was in relation to Gen 3.2, which requires the justifiably element to be considered, and it wasn't.
I mean, isn't 50 important in the context of this submission.
Yes, Judge, it's saying that, and I'll turn to consider proportionality in weighing up the competing considerations.
Yes, I mean, she's setting herself a balance between the private interest and the public interest.
Absolutely. But our submission isn't saying you fail to acknowledge that there is a proportionality assessment required, or that you didn't tell yourself that there was. Within the assessment of proportionality, which begins at 51.
I mean, I was puzzled by 51, but it's not been focused on by anyone as a ground of appeal. What does she mean by saying, I find the appellant meets the rules?
I think, Judge, as I say, she's referring to what she says under Gen 3.2, which is within the rules. But, and therefore, if you say that there are if you find there are unjustifiably harsh consequences, you might say that the individual satisfies Article 8 as contained in the rules. But
she doesn't say, yes, I mean, that is a weighty factor in the proportionality assessment in this. I mean, it's a conclusive factor if she's right.
Yes.
It's just muddled.
So there's two ways of looking at it. Either, and this is the point raised by my lady in the permission to appeal decision, she wasn't really finding that was the final point on the question, no matter what she said. She's actually just saying, I find that there's harsh consequences for this relationship, but I still have to go on to consider the public interest under these subsequent headings, in particular when we get to 117B. Or it's just a straightforward error. And why would the judge have gone on to consider everything else if back under Gen 3.2 she'd already found that the rules had been satisfied?
Right.
So it is muddled, but I think we have to take the benevolent approach my lady takes in the permission to appeal decision, which is to say it's essentially a sort of staged analysis.
Yes. Well, I think that's right. Okay, thank you.
So under proportionality, nothing about the public interest. The focus is on reasoning to justify a finding that there is family life between an uncle and his nieces and nephews. Then section 117B, which, as my learned friend says, is effectively a placeholder for public interest factors, beginning at 59.
Yeah.
Sorry, just going back to 52, she does say the legitimate public end identified as the maintenance of a firm and fair immigration policy.
Yes, you're quite right, my lady. There's effectively, in having regard to the legitimate aim, that it must be proportionate to. She notes that, but that's effectively prior to the actual proportionality.
Okay.
It's not a weighing of the specific public interest.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Right, well, we will continue normal business.
Don't know what that means, but I'll try and do it.
Now,
Attention please. Attention please.
you like to say everything twice.
This is the Incident Control Officer. An evacuation is in progress in the Queen's Building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Don't think she says it 3 times. Now, let's just see where we are. If you've got a minute or 2 more if you want to finish off on the point you were on, or do you want?
If that's okay, I would.
Yes, no, and
that's all right.
if I haven't got a feel for how long you're going to be. If you're going to finish in, would you rather stay on for 1/4 hour for you to finish?
Yes, I'm happy to do that.
If you would,
No, I don't think, my lord, I will be able to.
no, well that's fine. No, I didn't want to rush you at all. Well, then just finish the point you're on, and then stop.
Very good. So 117B, which again being benevolent, is effectively the public interest bit. Within it, we see 59. I now turn to the public interest. 60, looking at the case under the lens of 117B, I find as follows.
Yeah, we got all the.
Good English and integrated.
Yeah.
Which is essentially neutral factors incapable of availing the appellant effectively at all. 61, no criminal convictions. I accept that his immigration history is not ideal, but it's not the worst by any means. He came here on a 6-month visit visa in 2006 and left. He returned, so setting out some of the immigration history. He continued to make applications. So this is perhaps the closest we get to a consideration of the fact that at all material times, the appellant had no leave to remain. And it is done in the form of mitigation for not having applied, which is not the point. It might be completely accurate. The relevant point is that in weighing the family life she's just found existed, there's no assessment, no taking into account of the principle. Direction, application, reasoning. '62 goes on to talk about work. '63 is the employment point about Prime Minister. 64 is I note the respondent states it's in the public interest to remove the appellant. It's a strange point in time to turn to that, but it doesn't lead to any assessment of the principle in question found missing, not applied by the Upper Tribunal. '66 is effectively the EX1 principle, EX1B principle that you found earlier in discussion with my learned friend, which wasn't engaged. It certainly wasn't unjustifiably harsh, the test. And it certainly wasn't a reference to the principle that we're missing, precariousness. So, of course, when one has ringing in one's ears the ULA/HA-Iraq, paragraph 72, Lord Hamlin principles about how one approaches specialist fact-finding tribunals, one is, to use Lord Hamlin's phrase, slow to find misdirection. But here it's not, however slow you are, it's not there. You could take forever and it still wouldn't appear. And we've seen, which is why I began with the principles, how important it is and how there's no scope, however benevolent you are, to leave it out of account. So that's what I would say about the First Tier Tribunal, and I think it's a good point to stop before carrying on.
No, I think it is. Well, let's say 2:05, and it'll take as long as it can take. It certainly won't take all afternoon.
No, definitely won't.
Right. Thank you both very much.